So, friends, within hours of Special Counsel Jack Smith filing a motion to dismiss Donald Trump's federal election interference case, Judge Tanya Chutkan granted the motion, thereby bringing the prosecution to an end. So what now? Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Judge Tanya Chutkan, at Jack Smith's urging, dismissed Donald Trump's federal prosecution in Washington, D.C. for trying to overturn the results of the 2020 presidential election, for trying to steal the presidency from the American people. And she dismissed the case, quote, without prejudice, close quote, meaning that the case theoretically can be rebrought, be reindicted, and be prosecuted in the future. Let's start with the new reporting. This from The Hill. Headline, Judge dismisses Trump's federal election interference charges. And that article begins, President-elect Trump's criminal indictment accusing him of conspiring to subvert the 2020 election results is no more. U.S. District Judge Tanya Chutkan on Monday swiftly granted Special Counsel Jack Smith's motion to dismiss the case following Trump's election victory. Quote, the court will therefore grant the government leave to dismiss this case, Chutkan wrote. She dismissed it without prejudice, leaving open a theoretical possibility that the government can bring charges again after Trump leaves office. But the two-page opinion officially marks the end of the historic indictment brought last year, which charged Trump with 4 felonies over his efforts to overturn his election loss to President Biden that culminated in the January 6th Capitol attack. Earlier in the day, Smith moved to drop both of his criminal cases against Trump in alignment with a Justice Department policy against prosecuting a sitting president. So friends, let's take on 2 questions. 1, why did Jack Smith do it? Why did he move to dismiss Donald Trump's election subversion case? And 2, is there any hope, any realistic hope of Trump ever being prosecuted, ever being held accountable for the crimes he committed against the American people? And let's recall what those crimes are, what those 4 felony counts are that a grand jury indicted Donald Trump for based on testimony by almost exclusively Republican witnesses who appeared before that grand jury in Washington, D.C. and testified about the crimes of Donald Trump. Had this case gone to trial, Donald Trump would have been convicted with a chorus of voices that were pretty much exclusively Republican voices. Let's recall what those 4 crimes are that Donald Trump was indicted for. Count 1, conspiracy to defraud the United States. Count 2, conspiracy to obstruct an official proceeding. Count 3, obstruction of an attempt to obstruct an official proceeding. And count 4, conspiracy against rights. Conspiracy against our rights. Conspiracy against our voting rights. That's what Donald Trump did. So let's take on the first question. Why did Jack Smith do it? Why did he move to dismiss this case rather than just let the case remain alive, active, in existence, and into the Trump administration so that Trump could order his incoming attorney general to kill it, to dismiss it? Well, here is, I think, the main tactical reason Jack Smith decided this was the right thing to do. First of all, it gave him some control over how the case would be dismissed. Remember, we were talking a few minutes ago about how a case can be dismissed with prejudice or without prejudice? Well, Jack Smith correctly asked Judge Chutkan to dismiss it without prejudice to be rebrought in the future, which means there is at least some hope, however slim, that the case might be rebrought, reindicted, and prosecuted in the future. If he had let the case remain alive, active, in existence, and just make its way into the Trump administration come January 20th, then Trump could have told his attorney general and the federal prosecutors to march into court and move to dismiss this case with prejudice, such that it could never be rebrought in the future. Now, there are both procedural and legal impediments to that, to Judge Chutkan going along with the request that it be dismissed with prejudice. She could have said, I will dismiss it, but I disagree with your assessment that it should be dismissed with prejudice, so I will dismiss it without prejudice. But Jack Smith thought he would take that possibility, that litigation, away from the Trump administration and move to dismiss it without prejudice. Here's the other thing, and this is down in the legal weeds a little bit, but I think it's important to understand why Jack Smith made this tactical decision. If Jack Smith just let the case continue into the Trump administration, because the Department of Justice Office of Legal Counsel has this absurd opinion, absurd in my estimation, that we shouldn't prosecute a sitting criminal president. We should let a sitting president commit all the crimes against the people of the United States while in office with complete immunity from prosecution. That's the stuff of banana republics. I don't understand it. The Constitution doesn't say it. There's no precedent saying it. There's no federal statute saying it. It's absurd, but that's the opinion they take. And Jack Smith, as a prosecutor with the Department of Justice, governed by the guidelines and the policies and the procedures of the Department of Justice, even though he's special counsel, he said, listen, I have to abide by this opinion from the DOJ Office of Legal Counsel, so I have to move to dismiss it because it cannot survive once Donald Trump is sworn in. Had he not done that and had this case made its way as an active case into the Trump administration, Trump would have told his attorney general, listen, there's a policy that I, the sitting president, can't be prosecuted. Jack Smith should have dismissed it, but he didn't. He violated DOJ policy, and we're going to need to go after him for that. Yet this is Donald Trump's revenge and retribution tour, by his own admission. Prosecute the prosecutors, investigate the investigators. So they would have used that not only to dismiss the case, saying, well, we've got this DOJ policy that I can't be prosecuted now that I've been sworn in, and he would use it as evidence that Jack Smith violated DOJ policy. That probably would not have been a winning argument necessarily, but for those reasons and probably some others, Jack Smith did what he felt like he had to do. He was obligated to do. He was duty-bound to do, and he at least retained control over how the case would be dismissed without prejudice, which means it can be brought again in the future. But that brings us to the second question, maybe the more important question. Is there any realistic prospect of Donald Trump being prosecuted when he leaves office? Because probably the most important line in Judge Chutkan's two-page order granting Jack Smith's motion to dismiss Donald Trump's D.C. prosecution is this line. Dismissal without prejudice is also consistent with the government's, meaning the prosecution's, understanding that the immunity afforded to a sitting president is temporary, expiring when they leave office. So, friends, Jack Smith said it in his motion that he was seeking a dismissal without prejudice to preserve the ability to have prosecutors in the future rebring the case and prosecute Donald Trump for his crimes. And in her two-page order, her ruling, Judge Chutkan reaffirmed that and said, yes, this is temporary immunity that a president has against prosecution while he's in office, but thereafter he can be prosecuted. So now let's take on the question of how realistic is it that Donald Trump will be prosecuted in the future? And I want to hit on sort of three main areas of concern that tend to cut against the hope or the expectation that Donald Trump will be prosecuted in the future. The first is that when Donald Trump takes office and appoints an attorney general, that attorney general can direct his or her prosecutors to go into court and file what's called a motion to reconsider. And they could say, Judge, we understand that not long ago, before there was a changeover in the administration, prosecutors asked that the criminal case against Donald Trump be dismissed without prejudice. We're going to ask you to reconsider that ruling, and we're going to ask you to dismiss it with prejudice. Now, all I'll say about that is there are some procedural and some substantive impediments to that being a successful argument, but it is something that, you know, the Trump administration and whatever Attorney General Trump puts in place could try to do. Two, the United States Supreme Court has bestowed upon American presidents the power of lawlessness. They said presidents can execute their core constitutional functions, including issuing pardons, in a completely law-free manner. And not only can they do whatever they want, sell pardons, for example, but you can't even investigate or look behind their decision to deliver a pardon to somebody. In fact, you can't look into their intent and their motive. It could be criminal and corrupt all day long, and it doesn't matter. Because if we let you look behind the act, the core constitutional act of a president delivering a pardon, looking at his motive, his intent, his criminality, his corruption, it would somehow be an improper infringement on those core constitutional powers. That's absurd. But that's where we are. The Supreme Court granted presidents the power of lawlessness. So what might Donald Trump do once he's sworn in? I'm pardoning myself. Now, I've maintained all along that a presidential self-pardon should not be accepted by the courts as lawful or constitutional, and I think that was a pretty darn good argument prior to this radical right-wing extreme six-justice majority that granted presidents the power of lawlessness. They would probably say, he can pardon himself, he can pardon his family, he can sell pardons, he can pardon people to, shut them up because they could otherwise testify about his crimes. All good in our United States of America, our kingdom. So Donald Trump could deliver himself a self-pardon, and I assume the Supreme Court would say good to go. 3, if Donald Trump had some lingering concern about the constitutionality of a self-pardon, and we all know about Donald Trump's allegiance to the Constitution, then he could simply orchestrate a quid pro quo, this for that bargain, with his Vice President, J.D. Vance, and say, look, I'm going to go ahead and resign the presidency, maybe in a year, maybe in 2, maybe the day before I complete my 4-year term, because, I'm more interested in playing golf down at Mar-a-Lago than I am governing. And what I'm going to need you to do is when I resign and you become president, you will issue me a full blanket pardon for everything I've ever done in my life, a cradle to the grave pardon for Donald J. Trump, delivered by J.D. Vance, the new president of the United States. That is a third way Donald Trump could avoid ever being prosecuted when he left office, unless the Supreme Court determined that it was such a corruptly delivered pardon that they would invalidate it. Not likely from this Supreme Court. So friends, listen, I always have to call it the way I see it, and right now I see it as pretty bleak and pretty dark. You know that we're going to keep looking for the points of light. We're going to feed them. We're going to continue to talk about them. We're going to hope that they grow and they begin to overtake the darkness, but it's pretty dark. It's pretty dark right now. But we'll keep fighting, and I know that y'all will keep fighting because Donald Trump wants us all to lay down. He wants us despondent, depressed, right? He wants us to just throw in the towel. We ain't throwing in the towel. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.